What are some ways that you can legally get to see your child if you have a no contact order against you in a criminal case where the protected party is the other parent? Now that's a mouthful, but basically this is a video about some ways to legally get to see your child even though there's a no contact order that prohibits you from contacting the other parent. If that's interesting to you, or if this is your situation, stay tuned because this is the video for you. My name is Attorney Lance Fryrear, and I have a law firm in Linwood, Washington. We've been defending people charged with crimes for more than 20 years, and I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe so more people will get the help they need. There's not a lot of information out there. And so this is sort of a rough area of the law where, I put a lot of videos. I'm trying to think, well, what is it that I get asked a lot in my office? What's a frustration, or what's a fear that people have that are charged with a crime? And for this part, I'm talking about a domestic violence situation, domestic violence crime, where one of the parents has been arrested for committing some type of crime against the other parent. Most common, it's an assault in the fourth degree, a non-felony. While all domestic violence is serious, sometimes someone gets arrested, and that's not what the other spouse wanted, or the other partner wanted, and now we've got the defendant who has a no contact order, can have no contact with the parent of their child, and the order doesn't involve the child, but how can we get to see the child without getting arrested, right? Because if there's a no contact order, that also prohibits third party contact, which means, okay, I'm the defendant, I have a child or two with the alleged victim, and the alleged victim wants me to see the child wants to see me, but how can that be accomplished? So, these are my opinions. This isn't legal advice. You want to talk to your attorney. But how I look at a no contact order that says don't have any contact with the protected party and don't have contact through third parties, the third party provision I look at like this. You can't, in my opinion, that means you can't pass a message through a third party to the protected party. If the defendant is somebody named Bill, and Bill goes to his friend, and the friend goes to the protected party whose name Jan, hey Jan, Bill would really like to see his kid. Bill asked me to see if he could see his kid. Can he do that? Well, that might be third-party context because it sort of sounds like a message is being passed to Jan on Bill's behalf, right? So that's, and it would be even worse if it was, hey Jan, Bill asked me to tell you that he would like to see the kids. Well, that's definitely a third-party contact, and if that gets to the police or the prosecutor, that's going to be charged as a crime. So what's a different way to think about it? Well, the court has no ability to restrict the friend's behavior, right? The friend is not, charged with a crime. So what if the friend went up to Jan and say, hey Jan, I was just thinking, if the kids would like to see Bill, I can make that happen. So you can see that's the friend coming up with the idea on his own, not passing any message. That's very clean. And that's, in my opinion, very clearly not third-party contact. Third-party contact means the defendant directing the friend to tell that protected party something. So it's still risky because what if the protected party hears it differently or spins it differently? That can put Bill in some problems, right? But usually these situations I'm describing for this video are the parents want the kids to see both of the parents, but the court has sort of not made a provision for that yet. It's early on in the case, and now we're stuck. We're trying to obey the law. We don't want to get arrested. What do we do? It's sort of a nightmare for a parent, right? One of the many things that parents share as a fear. They're more worried about the effect on the kids than the effect on themselves. So that's one way, I think, to try to sort of delicately walk the line, right, about how you're able to see the child. I think a safer way is to, if the protected party wants this, if the protected party, the alleged victim, wants this, it's a really good idea for that person to reach out to the court or their victim's advocate immediately and say, hey, I want to get a hearing, to have the court write in some exceptions, to ask the court to write in some exceptions to allow us to communicate, at least through writing, for purposes of child rearing, child exchange. We need to talk in some way because we've got a family. We don't want to hurt the child more than he or she's already been hurt, do we? That is probably the safest and smartest way to do things, where it can also be the most convenient, where if the alleged victim wants this exchange to happen and there's no provision for it yet in the order, they can ask for it, right? And if the defendant is doing a good job, maybe the defendant's already done a class, or maybe the defendant's already done something to make it more reasonable for the court to write in that exception. We're not talking about parenting plans or divorces here. We're talking about dealing with a situation where there's a no contact order that prohibits the parents from talking, but yet there's a desire that each parent see the child, and how do we deal with that situation? It's pretty complicated. So let's say the situation is that the alleged victim in the case doesn't want the defendant to see the child, and then the defendant's like, can't I see my kid? Can't I ask for the criminal court to order that? Well, the criminal court doesn't deal with that. The criminal court does not deal with who has custody of children. They can enter blanket orders saying you can't have contact with the kid if the kid was part of the case, the kid was the victim, the kid saw the case, there's a reason to. But if you're in the situation where the other party, the victim party, is withholding and doesn't want you to see the kid and you're sure of it, well, then you have to make a decision, right? You need to talk to your attorney and find out, hey, if I go file a parenting action, or go file a dissolution in the superior court, is that going to work? Am I going to get a chance to see my child? And how is it going to affect my criminal case? Is it going to be putting gasoline on the fire of the situation and make it worse right now? Or is it worth taking that risk, right? It's a personal decision, but it also can have an effect on your criminal case. So it's something you need to think about, right? For the most part, I haven't seen, new crimes charged when the parents are cooperating, right? Trying to obey the order and doing things the way I first talked about. And many, many times the court will write in an exception. Oftentimes they'll allow only for written communication, and they might, put a way that could be exchanged if they want. They're not going to order it. But oftentimes they won't allow like telephone and stuff like that, because that gives more of a chance for the defendant to influence the alleged victim, or put control and abuse on them, that type of thing. So if things are in writing, it could at least be checked up on later. So again, this is just my opinion and the way my firm has often advised our clients for a long time without problems, but you need to listen to your own attorney. This isn't legal advice, and you have to read your order. Every situation is different. But I thought I'd just put out this video to let you know it's not hopeless, that things can be done. And just because you have a criminal order doesn't necessarily mean that you're not going to be able to see your child while this whole case is going on. It's complicated. No one ever said it's fun to be charged with a crime. But I think there's hope out there. So if you found this useful, I hope you can like and subscribe so more people can get the help they need. And if you're in a situation where you've got a criminal matter in Washington State and you need some help, feel free to give my office a call. Again, my name's Lance Fryrear. I've been doing this for more than 20 years. If you reach out to us, we'll listen to what happened, we'll identify a way forward, and we will be there for you. Thank you.